Also says small acts of independence, such as wearing pants and getting a nose ring, were met with hostility.
Anyone who is making decisions for themselves that the parents don't give their blessing, that's seen as rebellious. Kind of protected my brother, but then used me and some of my sisters. It was hard.
The Joseph Duggar case moved significantly this week, and there are multiple developments happening simultaneously that paint a very clear picture of a defense strategy that is becoming increasingly aggressive and increasingly desperate. And I want to walk you through everything carefully because understanding the legal context is essential to understanding why what is happening right now matters so much for the victim and for the integrity of this entire case. Starting with the court hearing last week, Joseph's attorneys showed up and essentially told the court they were not ready to argue the pending motions that day or even the following day, and the prosecutors were ready to proceed, and Joseph's team then mischaracterized the prosecutors as also needing more time when that was not what the prosecutors said, and ultimately the parties agreed that the motions would be addressed at the July 14th pre-trial hearing, which seemed to indicate a couple months of relative quiet in the case, but that quiet lasted approximately 1 week before things started moving again rapidly. In the period following that hearing, Joseph's team filed a second motion to remove no-contact restrictions, this time specifically seeking permission for Joseph to go within 500 feet of the former address of the victim's family, the same address that appeared on the public court docket in violation of Marcy's law the previous week, the same address that the state had to file an emergency motion to have removed and sealed. And Joseph's justification is that the family has abandoned the property and moved away, which, as has been discussed, creates the significant legal problem of how Joseph knows this information, given that someone would have had to physically go to that property to verify it was vacant, in apparent violation of the existing no-contact order. Then, on the same morning that prosecutors filed their first supplemental discovery, meaning new evidence being added to the prosecution's case against Joseph, Joseph's attorneys suddenly requested that the modification hearing be moved up from July 14th to June 16th, and the timing of that request is not coincidental, because the filing of supplemental discovery means the prosecution is continuing to build and strengthen its case, and Joseph's team apparently wants to get in front of a judge as quickly as possible to try to secure modifications to his bond conditions before the weight of the evidence against him becomes even more substantial. Understanding what supplemental discovery means is important here. It is different from responding to a motion to compel, which is about evidence that already existed, and instead represents the prosecution's ongoing legal duty to disclose to the defense any new evidence as it is discovered, meaning that the state has developed new evidence in this case since the initial discovery disclosure in April, and that new evidence is significant enough that the prosecution was legally required to formally notify the defense of its existence and turn it over. And the fact that this supplemental disclosure triggered an immediate request from Joseph's team to move up the hearing date tells you that whatever is in that new evidence has made the defense feel urgency about getting their modification motions heard before the full picture of the evidence against Joseph becomes clear to the court. What could that new supplemental evidence include? The Washington County Jail calls and emails that were released publicly are now in Florida prosecutors' possession, and some of those calls were partially redacted at the time of public release due to ongoing investigations, meaning there may be content in those calls that the public has not seen, but that is now in the hands of Florida prosecutors. And as time has passed and the victim has entered therapy, there is also the possibility of additional disclosures that have emerged through the therapeutic process, because it is well documented clinically that children who have experienced trauma often have more information emerge as they work through what happened to them in a safe therapeutic environment, and any additional disclosures made by the victim would be part of the supplemental discovery that the prosecution is required to hand over to the defense. There is also the possibility that new witnesses have come forward, people who were aware of things Joseph said or did, people from the broader community who have information relevant to the charges, or potentially people whose own experiences with Joseph have become relevant as the investigation has continued to expand. and all of that new witness information would be part of supplemental discovery. The confession remains at the center of everything, and it is worth being very direct about what that means for the judge's evaluation of Joseph's modification requests. A judge in a child sexual abuse case who has access to a recorded confession cannot discount or ignore that confession when weighing whether to modify bond conditions. The confession must be weighed against the safety of the community and the safety of the children who are the subjects of the pending modification request, and the strength of a recorded confession is extraordinarily high as evidence. And a judge who is considering whether to allow Joseph increased contact with his children or decreased distance from the victim's family has to consider that this is a man who confessed on record to sexually assaulting a child and who has an ongoing child welfare case in Arkansas, where his children were removed from his care based on findings that he and Kendra were not safe or fit parents. The Arkansas dimension of this case is something that the Florida court cannot override, and this is a critical point that appears to be at the heart of what Joseph's legal strategy is actually trying to accomplish. Because Arkansas DCFS made a determination that Joseph is not safe to parent his children and has not assigned any qualified supervisor for Joseph to have contact with those children, meaning there is currently no court-appointed supervisor in either Florida or Arkansas who has been approved and deemed qualified to supervise Joseph's contact with minors. And Kendra cannot serve as the supervisor because she is still involved with Joseph, and in a DCFS case, every person who would have contact with the children must be independently assessed for their ability to comply with court orders and not interfere with the investigation or influence the children's testimony or statements in any way. And Jim Bob and Michelle Duggar cannot be supervisors for the same reasons. What appears to be happening with Joseph's aggressive push to modify his Florida bond conditions is a strategy to get a Florida judge to issue an order allowing contact with his children, so that the order can then be used to argue in the Arkansas proceedings that Florida has determined he is safe enough to see his children, essentially attempting to use one jurisdiction to create leverage in another jurisdiction. But this strategy has a fundamental flaw, which is that a Florida judge's modification of bond conditions does not override and cannot supersede what DCFS in Arkansas has determined about the safety of those children. And Arkansas child welfare authorities will continue to apply their own standards regardless of what a Florida bond modification order says, meaning Joseph would be getting a Florida order that he could wave around publicly, but that would have no practical effect on whether he actually gets access to his children in the state where they are located. The deeper motivation behind all of these legal maneuvers is something that sources close to this situation have been clear about. This is not primarily about Joseph genuinely wanting to be a present father to his children. This is about preventing Kendra from leaving him, because the pressure that Arkansas DCFS is putting on Kendra as part of her reunification process includes the clear message that as long as she remains with Joseph, she cannot be deemed a protective parent and cannot regain custody of her children, and Joseph is attempting to manufacture a scenario where he can say to Kendra that a judge has said he is safe to see the children, that they can be together, that there is a path forward as a family unit, as a way of convincing her not to take the steps that would actually give her a chance at getting her children back. Kendra's phone calls with Joseph revealed the internal conflict she is experiencing. She acknowledged at one point that she needed to make her children her priority, and that she would have to separate herself from Joseph to have any chance at regaining custody. And then the pressure of Joseph's manipulation and the Duggar family system apparently overrode that moment of clarity. And by the end of that same period, she was talking about the two of them working together. And this cycle of Kendra almost reaching the conclusion that she needs to leave, and then being pulled back, is something that is deeply familiar to anyone who understands how coercive control operates. And Joseph's legal strategy is itself a form of coercive control extended into the courtroom. He is using legal motions and hearing requests not primarily to advance a legitimate legal defense, but to create circumstances that keep Kendra emotionally and psychologically tethered to him by making her believe there is still a version of their life together that is possible. The bottom line of everything happening in this case right now is that the prosecution is building a stronger case with new supplemental evidence. Joseph's defense is responding with aggressive motion practice designed to look like active advocacy, while actually serving the purpose of keeping Joseph's bond conditions as loose as possible and preventing Kendra from taking the steps necessary to protect herself and her children. The Florida court cannot override what Arkansas DCFS has determined, and the only path that leads to those 4 children being safe, and Kendra having any chance of rebuilding her life, runs directly through her making the decision to separate from Joseph permanently and cooperate fully with both the Arkansas and Florida proceedings. And every day that passes where she does not make that decision is another day that those children remain in the foster care system, and another day that the window for her to demonstrate she can be a protective parent grows smaller.